Welcome back to the morning show here on Arise News. For a conversation on a range of issues currently affecting Nigeria's national interest and even corporate existence. We are now being joined from Arise Abuja studio by Professor Auwalu Yadudu, a professor of law who served as legal advisor to the late Nigerian head of state, General Sani Abacha. In 2014, he also served as the deputy chairman of the National Conference Standing Committee on Law, Judiciary, and Human Rights. Welcome to the program, Professor Yadudu.
Welcome to the program.
Good morning, thank you. Thank you for having me.
Good morning, Prof, and good to see you again. Well, let's start with...
Well, good to see you, Ruben. How are you doing?
I'm fine, thank you, I'm fine. Now, let's start with the outcome of the election petition tribunal, the Presidential Election Petition Tribunal, that is.
Yes.
Looking at 5 grounds of the petition by the petitioner, the PDP candidate and the PDP itself. What are your thoughts on what has happened? Do you think it's a good idea that the petitioner can still get any relief if he goes to the Supreme Court, or you think that the matter has already been fully settled and going to the Supreme Court to challenge the outcome may just be an exercise in futility?
Well, my assessment of the judgment of the court is that I think it is sound, it is well reasoned, but the fact that it is sound and well reasoned does not mean that it cannot be found wanting in one way or another going up on appeal. But secondly, going on appeal by a party who is aggrieved with the verdict is his right, or is either the candidate's right or the party's right to test the outcome or the verdict of the tribunal. But as I said, I would not want to conjecture as to what would be the outcome on appeal, but it would be a tough one getting the verdict of the tribunal, which I have deemed to be sound and very well reasoned, to be overturned.
Okay, Professor, and how do you feel in terms of your confidence towards our judicial system when it comes to tribunals this big? They symbolize a lot for democracy when you have a former vice president going against the current president on such a strong case, which is the 2019 general presidential elections. Do you think that in any situation whatsoever, given a case this big, even if it were a ruling that were in favor of the former vice president, the country would be put into that kind of position? What kind of faith and trust do you have in the judicial system and the way it functions?
My personal and principal view is that I think elections should be settled at the ballot box, and that if the votes have counted and the will of the people as expressed through the ballot has been fair and balanced and free, I would not want to see any role for the judiciary getting involved in determining the verdict one way or another. I think essentially elections are matters for the voters, and if the voters have spoken, it would be my preference that disputes do not have to go to the judiciary for settlement one way or another. The reason being, first of all, the judiciary, once it is election season, time is taken up, and the other things take the back seat, and also they are necessarily exposed to very partisan political contest, and however sound their reasoning and judgment based on evidence available before them, they are exposed to insinuations of bias one way or another. Now, that doesn't bother me, or it shouldn't bother them. Whatever the outcome, they would be exposed to that. But I think preferably, I would think that maybe going forward, without denying a party who is aggrieved from an electoral process to seek for redress. I would prefer that disputes or election matters start and end with the voters, and that if it is free, fair, and in accordance with the Electoral Act, there shouldn't be the need for anybody to go upstairs to check and seek to overturn the verdict of the people. Now, having said that, I have confidence in the fact that if the judiciary, in the way our election tribunals have been set up, are called upon to adjudicate on the such electoral disputes, I think they have, over the years, in the last 4 or 5 elections that we've gone through, definitely one could see an improvement in the comfortment, and also in the openness, and in the reasoning, and even in the lower, perhaps even fewer or no cases of maybe judicial members being compromised on election dispute. Remember, in the last 4 previous elections, a lot of members of the election tribunals fell by the wayside because they were compromised. But of course, such bad eggs would also be bad eggs, whether it is in relation to election petitions or it is in relation to other matters. So, to your question, my preference would be let electoral matters be settled at the ballot box in accordance with the rules, and that we should spare judiciary so that we also do not expose them to unnecessary exposures, and also we do not tempt them or maybe drag them into the fray of the political disputants.
Well, Prof, I get the impression that we are invariably asking for sportsmanship on the part of politicians when you say they should accept the outcome of the elections, yes, according to the rules. But that may be a lot to ask for, knowing that politicians in Nigeria do not necessarily behave like sportsmen. They see elections as a war season, and that's why I think this year we even have more petitions than we've ever had since 1999. But we discussed the same subject on this program with Chief Robert Clark, SEN. And he was saying that his concern is that too many cases are taken to the Supreme Court, that do not need to go to the Supreme Court, election petitions. And he was recommending, maybe the establishment of a constitutional court, which can take care of election petitions instead of, the apex court being distracted from its main duty with election petitions that can only be determined more on the basis of facts rather than any new details about the law. What do you think? Do you think a constitutional court will help to reduce the burden on the Supreme Court? Well,
having a constitutional court designed specifically to address matters pertaining to pre-election disputes and ultimately election disputes outside the existing constitutional arrangement is an idea that was, I think, given thought to during the 1995, what some call as the Abacha Constitution. I think the 1994 Constitutional Conference did recommend, and I think the draft constitution did contain a proposal for the establishment of a constitutional court. Now, again, in the Vision 2020 exercise of, I think, 2006 or 2007, there were also such proposals for the establishment of a constitutional court. Now, the problem with having a constitutional court specifically for election is that we will have too many more courts, too many more jurisdictions, and only set aside for the purpose of election. And don't forget that we conduct elections periodically at intervals of 4 years, and of course, except off-season elections. So I don't think if we are going to propose a constitutional coercive for the purpose of dealing with election matters, you can give it some additional jurisdiction, but I think you still have to consider whether you are having too many courts to decide and adjudicate disputes. Now, the Supreme Court at the moment does not sit as the Supreme Court, but as an election petition appellate tribunal. And it's only at this interval. So it is not that the Supreme Court's time is being taken over. Actually, come to think of it, it is more the time of the high courts of states and the federal high court, from which members of the various election petition tribunals are drawn, that suffer more than the Court of Appeal or the Supreme Court. The Court of Appeal, hears appeals irrespective of disputes arising from the lower tribunals, but the Supreme Court only hears, as a panel, only hears appeals in relation to presidential elections. So, to me, you do not need to create too many more forums or fora for dealing with matters that are occasional in nature and not regular or maybe routine day-to-day issues that you need to dedicate attention to.
Well, Prof, thank you very much for that. But you've made a lot of comments in the past on the electoral process in Nigeria. Now, after these 2019 general elections, INEC has been talking about further reform of the electoral system, lessons that we can possibly learn, and changes that can be made to the electoral law. Some people have even said it's strange that we're still arguing over the use of server or no server in 2019. I would like to have your thoughts on some of these issues, what you think we can do to deepen the electoral process in Nigeria, considering our recent experience and the experiences we've had since return to civilian rule in 1999.
Quite evidently, the election manager and the electoral process and the stakeholders have, over the years, identified areas in the electoral process and in the election management that need improvement. And we have had incremental improvements in electoral law and even in constitutional amendments. Now, I'm aware that just before the election that took place, national election, there were proposals for the amendment of the Electoral Act as well as certain parts of the Constitution, which did not see the light of the day. I think it will be well to revisit those recommendations. The only caveat I would want to add is that it's always not a good idea to begin to amend the rules of the game just as the game is about to start. There is time between now and the next general election. I think if there are any areas we need to improve, now is the time to start it, and so that we will be able to, without the veneer and partisanship of an impending election informing our decisions one way or another, get done with areas that we would need improvement. There are very many areas that can be improved upon, including, of course, the way election disputes are disposed of, even the use of electronics in the conduct of either the election or the transmission of the election results or the verification, because, of course, as you perhaps some have observed, the judgment of the tribunal on the use of the smart card was not dismissive as some have made it. I think the court merely said that it is a means of further verification. It is not totally jettisoned, but I think if there are ways that we think we can further enhance the use of the smart card, and also the way we transmit results, or even the way we participate in the electoral processes, these should be discussed well beforehand, and areas of fears for compromise and hacking and what have you also addressed, so that all the stakeholders are comfortable with it, so that we can have a piece of electoral act improved for future national elections well before the time for the election. But I'm happy that there are, or there have been, improvements in the Electoral Act, in the constitutional provision pertaining to elections, which we can still further improve given the opportunity to do so early before we start another election round.
Absolutely, Professor Yadudu. I'd like to hold you there for a second. We do have some breaking news. Now, ahead of the Revolution Now protest that has been scheduled for today, there are reports reaching us that a detachment of policemen has taken over the premises of Sahara Reporters' Lagos office off Isaac John Street in Ikeja. Now, workers have been denied access, as claimed, from their offices from as early as 7 a.m. this morning. And those are reports just coming into us now. But Professor Yadudu, what is your take on this? We're hearing now that the police have stormed to the Sahara Reporters' office on Isaac John Street in Ikeja ahead of the Revolution Now protest scheduled for today.
Well, one does not have the facts as to why the police or the law enforcement agency would want to seek to invade or maybe seek to investigate or search a premise. Well, in this case, the premises of a newspaper organization. So I think they had better have good basis for doing so, rather than sending the wrong signal as to people speculating as to why they are doing it, or you know, we are good at going wild in our speculations. But as I said, one does not have all the facts to be able to either approve of or condemn what may have happened.
Well, Professor Yadudu, I mean, let's go back down memory lane. You were legal advisor to late General Sani Abacha, and you were considered a very powerful legal advisor, even in fact more powerful in some people's estimation than the Attorney General of the Federation. When you look back now...
Will that be your view as well?
No, well, no, I'm just reporting what I've heard. I'm not expressing an opinion. You know, but when you look back now, do you have any regrets serving in a military government? And then secondly, what do you think of what the current administration has done, declaring June 12 a national holiday, and also immortalizing the late Chief MKO Abiola?
Well, I have said this again and again. I served in a professional capacity, and what professional advice I gave or did not give, what action I approved or did not approve, is not a matter that I would come in in an open arena to begin to recount, because many may not believe me. So, but I think my answer to this is always that I have no regret as to what I know I have done in my professional capacity as a lawyer, and I was not a politician, and I was not a military man. So that is the simple answer. I have no regrets. There are things that could have been done otherwise. It was a military regime. It's not a regime governed by what we have now as a constitutional system. So one had to take it as it came. Now, as to your other question, and what was it, sorry?
About June 12 and MKO Abiola and the decision of the current administration in that regard.
Okay. Yes, I think it is a very welcome decision. It is one that has been given due consideration. An event had happened. No one had any doubt as to how free and fair the election was in 1993. It was subverted one way or another, and the fact that we are now reconciling ourselves with that event in the manner that the administration has done now should not be a problem. Actually, should be something to be welcomed. Of course, we should also, or I hope we have learned other lessons from that, and that we can, as politicians, we should learn many lessons from what had happened during those election processes and build further on our democracy.
Thank you, Professor. Now, we're living in times where a lot of history is repeating itself, shall we say. But a topical issue right now is the xenophobic attacks that have gone on in South Africa towards Nigerians and other African nationals. Now, if we recall, in 1996, Abacha pulled out of the Nations Cup in South Africa. What were his reasons behind this? Is it for similar reasons that we are seeing today? Briefly, please, also, Professor, as we are running out of time. Sorry.
I think the reasons were, of course, there were no xenophobic attack at that time, but I think there were political reasons. It's a matter for reciprocity in political and diplomatic relations, if I can recall what had happened. But I mean, coming to what is happening in South Africa and other parts of the especially in South Africa, I think my view is that there are also lessons we should learn from that, that we seem to justifiably feel...
Sorry, I'm so sorry, Professor. We have run out of time. It was lovely having this conversation with you, and hopefully we can continue it again sometime. Thank you.
Thank you very much, Prof. Thank you for your time.